Good evening. Tonight is Wednesday, 9 p.m., and my name is Elena Shevtsova. I'm a Brooklyn immigration attorney, and we continue our Legally Speaking series. And today's one is dedicated to fashion models. New York City is the fashion capital of the world, and it's just natural that many girls and boys who are performing in the fashion industry would like to come here and find good contracts. Unfortunately, immigration laws do not provide a special category for fashion models that will be allocated specifically for this group of employees. It means that fashion models have very limited immigration options in the United States. And the two main options would be an H1B3 visa and an O visa. H1B3 visa is a type of a H1B visa, and hence it's subject to all the rules that an H1B visa would be subject to. For example, while a fashion model, does not have to hold a degree or equivalent experience as other H1B workers would have to, a fashion model have to be a person of distinguished merit and ability in order to be able to apply for an H1B3 visa. This visa comes with certain limitations. It's employer specific. An agent who is booking the performances and collects fees is not an employer. So it has to be a different entity that employs the model. Employer has to file a labor certification just like any other employer in H1B category, and it can be troublesome because on the labor certification, basically an employer verifies that employer will pay a certain level of wages to fashion models, and fashion industry is very different. It's not like other um, employment venues where there are stable wages. That's why many agencies would try to stay away from an H1B option, H1B3. Perhaps the most inconvenient in this situation is the fact that fashion model visas for fashion models under this category are subject to a cap and certain time limitations. It means that the petition may be filed no earlier than April 1st, and the work that would be performed cannot be start earlier than October of the year. So those are the main limitations for the H1B 3 option. uh, what one does have to show to qualify for that visa? Well, as I said before, like in other industries, there are no requirements for um, education, but here a model has to show that he or she performed for distinguished maybe designers, or was invited to perform at distinguished venues, let's say Fashion Week in New York, or maybe in their home country. There is something similar to that. And sometimes a model can qualify for the visa by showing that she or he was paid high fees for their services. So there are different specified requirements that petitioner has to comply as well. That's very important. And as I said, the main inconvenience here would be time limitation and quota limitation. Fashion models in H1B3 category they have to compete for the visas with all other employees who would like to come into the United States and work in the United States in H1B category. The other option would be an O visa. The O visa is more flexible in terms of the um, when a person can apply for it. The O visa also requires a petitioner who would be sponsoring the model. An O visa does not require a labor certification, but it does require an itinerary. It means that the engagement of this model would have to be unfolded before the USCIS, before the model comes here. Otherwise, the USCIS may decide that the employment is speculative. It means that, well, you just would like to come into the United States and you don't really know if you are going to be engaging in employment. So that's what an O1 visa difficulties are. And of course, the main difficulty for the O1 category is the extraordinary ability standard. Here, the standard that the fashion model has to show in order to qualify for a visa is much higher than for H1B3 visa, and probably an O visa would not be um, a good, easy choice for most of the models. That's why an H1B3 probably is better. Um, for the other uh, requirements in connection with the H1, I'm sorry, in connection with the O1 visa, I would mention that the good thing about the O1 visa is that there is no time limitations a model can hold the visas for, unlike with H1B3 that's typically is given for 3 years and can be extended one more time for 6 years. An O visa does not carry that limit. So those are the main two options. If you would like to learn more about these options, you're welcome to visit my website at www.shoutsova.com and call with questions. And I would like just to add one more important things for fashion models. Those models that are under 18 may face extra requirements that they have to meet, or the employers, let's say, have to fulfill extra requirements if they're going to engage in employment in certain states or cities, let's say New York City, because New York City just promulgated a specific regulations for child um, employees, and the fashion model under 18 would fall into that category. So all those little details very important to know when one is applying or petitioning for a fashion model. And I hope this little video was helpful. Thank you.